Good afternoon, everyone. Looks like we have most everyone here. We may give another minute or so, make sure everyone gets signed on who needs to be, but welcome. I'm going to go ahead and introduce our presenters for today, and then they can maybe give a quick talk about themselves while we make sure everyone's signed on. So without further ado, we have Garrett Kern and Andrew Murray, both vice presidents at the ISBA Mutual Insurance Company. And thank you all for presenting today to our associate fellows, and welcome as well. And I'll let you take it from here.
Thank you. As Krista indicated, my name is Garrett Kern. This is Andrew.
Hello.
We can't see anyone, so just so you know, if you're raising your hand, we can't see you.
Let me see if I can get.
Yeah, I don't know if that's our thing, but in the meantime, again, my name is Garrett Kern. I run the claims department here at ISBA Mutual. I am a licensed lawyer. I graduated from Loyola here in Chicago in 2001 and was admitted in November of 2001. I was in private practice for about 13 years before I entered into claims, mostly professional liability and most recently in legal malpractice. So I've been in this role for about 2 years. I've handled legal malpractice claims for about almost a decade. So I'm here. I'm happy to present some information to you all, and we hope this is informative. And I'll turn it over to Andrew to give a little update.
I'm Andrew Murray, and I've been with the Mutual for 16 years. And one thing that we really focus in on, obviously the insurance product, but really kind of helping people understand what it actually covers, what the risks are. And our focus is solo and small firms, and really help people understand what kind of they need to be aware of, that what causes claims, what can prevent claims, risk management, that kind of thing. So what we really try to do is kind of a fully comprehensive service on really understanding on how to best practices and that kind of thing, kind of safeguard your practice. So we're having a little bit of an IT issue on seeing everyone, so we're trying to rectify that. Okay.
So we're being told that everyone has their video off, which is why we can't see you. I don't know if that's how you guys typically do this, or hi, Krista.
Which is
Hi.
fine. We just didn't know.
However you want to do it.
On our end, yeah.
I was going to say, it's typically optional unless the speaker requests
sure. Okay.
specifically. So it's kind of up to what you guys want.
We'll leave it up to you. It's just,
Yeah, gotcha.
We just hope that it's going to be interactive, answering your questions, posing some questions. I promise not to pick on the only people who are who braved to put their video on, so we appreciate it. It's just easier to talk to a face. So getting started there, I was hoping everyone could maybe just briefly introduce yourselves to us. Your name, maybe what firm you're working at, whether you've been licensed or when you plan to get licensed. And I don't know how you're going to start, but just someone jump in. I'm looking at Hannah Rogers just because you're in my upper left.
Hi, I'm Hannah Rogers. I'm working at Brown Law Group currently. I forgot your other questions.
Oh, when you're taking the bar, if you pass the bar, that
Taking
kind of
it in
stuff.
February.
Oh,
nice.
good luck.
Thank you.
All right, who's next?
I'll jump in. Hi. Oh, hi. I'm Angel. I'm the chair of the Serving Rural Lawyers Committee. I'm vice chair of the Rural Practice Initiative Committee. I am a licensed attorney, as you can infer from all of that. And I'm practicing at Armstrong Grove and Warzenic in Mattoon. And so I'm just here to be helpful as I can and a listener. And also I'm going to be eating lunch. So I don't mind my camera being on, but now you can't judge me while I try to cut my apple and eat my lunch.
It's a working lunch.
Let's do it cleanly.
Gotcha.
I think we have one more person on the video.
Yes.
I can't tell who that is. Oh,
Jenna Graham.
Hi, my name is Jenna. I work at the Costantino Law Firm. We're located in DeKalb. I am licensed. I just got licensed in November. I've been working primarily. Thank you. Primarily civil litigation, real estate, and family law, and a little bit of
Nice.
criminal. I've tested the waters. So.
Gotcha. And I was actually looking up, I saw that you started as a law clerk at that law firm and kind of made that transition.
I did.
How's that transition
for-
from something law?
Good. I've been here for 3 years. I started actually, one of the attorneys was my mentor through my law school's mentor
nice.
program, and we just hit it off. She offered me a clerk position. Actually, I worked with Hannah too, so.
Okay. All right.
We both went to NIU, and then
Okay.
and then I started here as an associate.
Cool.
You guys,
Well, we
Simone is on her office computer that doesn't have a mic or a camera, so she can't really communicate. But Simone, she can hear us, and so if she has
Okay.
questions, she can just chat me, and I can
Okay.
relay them. Okay.
And then my
Okay.
name's Michael Lawler. I'm with McMillan, Hennepin, DeJody, and Macomb, mostly doing rural farm transactions. And I'll be taking the bar in February.
Very nice.
Good luck. Another rambler, I see.
Yes, I am.
Okay. Well, I guess in that case, we'll just get started. As Andrew said, one of our goals here at the Mutual is to not only provide legal malpractice insurance, but also to educate and provide resources to our insureds, to help them in their practice, help them develop a better working knowledge of how they can keep themselves out of malpractice claims. And to generally, one of our things is elevate the business and practice of law. So we hope that through our presentation today, we'll at least get you thinking about your role in that, in developing that for your firm, not only your own personal practice as you move forward, but also the firm, within which you work. One of the things that I recognized as a young lawyer was that it took me a while to learn, I should say, was that I was more than just a billing machine, or document reviewer, a status conference attender. There's value to having associates and to having young lawyers in the firm beyond just those very important roles. Don't get me wrong. One of the things that I like to talk about when I'm speaking to younger or newer lawyers is that there are ways that you can help your firm in terms of avoiding malpractice claims. I mean, that's why we are here. That's what I deal with every day, defending our insureds, paying out claims when necessary, and answering their calls on risk management. It's a service we provide to all of our insureds. You, as employees of the firm, whether you are currently a lawyer, whether you're currently a bar pending, you are an insured under your firm's legal malpractice insurance carrier. So what I'll ask you rhetorically at this point is, do you know the name of your firm's insurance carrier? Do you know how to get in contact with them? Do you know that you were an insured before I just told you? Did you know that the nature of that policy is one of it's what's called claims made and reported, which is different than your typical car insurance or CGL, which is incurrence based, and what that means. Again, I'm not asking anyone to answer those questions, just things that you should know, hopefully by the end of this conversation, to at least figure out and find out from those members of your firm with that information. So on that point, we'll talk a little bit about what is legal malpractice insurance. Why do you have it? The state of Illinois does not require that you have it, but we think you should, and not just because we want the premium. Because mistakes, as Andrew can tell you, mistakes are going to be made. We're imperfect. You have, and I have, and our insureds have all gone into this business of law, whether it's criminal, whether it's real estate, whether it's municipal, transactional. It's a service at its very basic nature. It's a service. And when you do a service for someone else, you're often going to disappoint. and they're always not always going to be happy, and they might be unreasonably unhappy. So in the sense of what can you do as an associate, as a law clerk, as someone who's going to be working toward your client's best interests to avoid malpractice claims, the reality is it's not a matter of if it will happen, it's a matter of when. And whether that be an actual lawsuit, whether that be a claim, you receive a letter from an unhappy client, or whether it be you get an ARDC complaint filed against you.
And one key point that Garrett made as far as errors can be made. One thing to kind of understand about legal professional liability insurance, the typical kind of conception is it's to protect the lawyer and the law firm. That is true, but it's also built, it's really a third party contract. It's really to protect, it is a liability policy to protect if there's an error. So our responsibility of an insurance company, if there's a suit against you, we want to defend that lawyer, defend that law firm, make sure we're doing our duty in that respect. But realistically, errors do happen. And if an error does happen, let's say a statute's going on injury case or something like that, and it's there's no more case, we want to make sure that we're making your client whole on that. So it's important to kind of think about the importance of that, because if there's something that goes wrong, and one thing that we want to talk about is help to kind of mitigate where the kind of potential wrongdoings are.
Right. And I will say that one of the things that we talk about here internally, as well as talking to other, when we're doing risk management, is identifying the errors quickly. And one of the things that I run across it, if not daily, it's certainly weekly, are associates primarily, or even partners to a degree, burying their mistakes, thinking they can outrun them or outlive them, or they'll just resolve themselves and hope that no one ever catches the mistake. And I can tell you, after doing this for 10 years and litigating before that, they never go away. So my number one recommendation that I tell everyone, the number one thing you can do to help yourself and help your firm is don't bury your mistakes. You have mentors, you have resources, you have partners in the firm who brought you in to assist you. Go to them. I have a case right now, a claim right now, where an associate who was brought in, was a lateral hire, brought in to handle complex real estate closings. Got handed a file, realized he was way over his head, but felt like, hey, he got brought in to do this kind of work. So, told his assistant asked, hey, how's everything going? Everything's fine. Told the partner, hey, we're coming up on that closing date. How's it going? Everything's fine. The assistant saw him on the phone, was helping him build time, organize his files. The, partner didn't think to go look into the files at all. Thought, all right, I've hired this person, he'll handle it. I don't want to be that overbearing partner, micromanager. And, by the time, the associate realized he was so far in that he couldn't get himself out, hoping that it would resolve itself, something had been missed, and now he's got to go and, ask for help, maybe a little bit when he should have been asking help in advance. These are the things that we think, then that gets reported as a claim, right? The closing didn't go, so there are going to be expenses related to that. And there are going to be, conversations that are uncomfortable because maybe this partner has had this client, maybe it's a family client, someone who's been in there, their family has used them for years, and they have to have an uncomfortable conversation. I will tell you, uncomfortable conversations, so one-on-one conversations where you explain the mistake, to not only to your partner, to the attorney handling it with you, but to your client, those knock off, I don't know what percentage of malpractice claims, because we don't know what didn't happen. But I can tell you that we get reports all the time of what we call potential claims, and a conversation is had with a plan to rectify the problem. And I'm not saying the claim goes away, but I'll say it goes a lot smoother toward resolution. So one of the things I'll say is, tell your mentors, tell your partners, I made a mistake. You're not expected to know everything. I remember as a law clerk, I had an attorney who had just taken the bar say he knew, how did I say it? The most he ever knew about the law was within like the month before and the month after he took the bar exam, because he just studied for months straight, and then it took him a month to forget everything, and then he didn't know anything after that. So I guess the point being, no one expects you to know everything. Humans are fallible, and that's why we're here. That's why we have insurance, because we're in this service industry, and we want to make your clients whole if there is an error. So another issue on that is another claim I have. We had an associate who, after reviewing, who left the firm, and the partners went back, started reviewing her files, and it was clear she'd been planning on leaving for about 6 months, 7 months, 8 months, and just let everything kind of go. So we get the call. Here's a list of 10 potential claims that we identified, whether it be, the summons was issued but not served, aliases were not requested, what have you. It was all 103B, 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 just all down the line. The firm is stuck with that. And yes, the partners, they realized they should have been on top of these files a little bit more. But that's going to follow. I mean, the reality is, whether that associate went to another firm that's insured by the mutual or insured by another carrier, those claims, in a sense, will have that attorney's name on them. So I guess what I'm saying is, don't bury your files, don't bury your mistakes, and report things that you think may become claims.
Yeah, and so one of the baselines is don't be afraid to let the carrier do what they should be doing. What we should be doing is defending these matters. So early reporting, we operate like a different line of insurances. Anything that was reported to us doesn't necessarily mean a bad thing. It can be a good thing, because it's not like an auto insurance where there's already an accident. The accident's already happened. What we want to do is to be ahead of the game. Maybe there could be a client that's disgruntled or express some displeasure. The earlier we know about that and get the information, and can make an analysis, potentially resolutions, before there's the accident or malpractice claim, so to speak, it puts us in a better position to come up with a strategy and kind of help, mitigate the problem of a potential major issue. So just want to kind of change the mindset of allowing the carrier to do what we do, which is to defend you.
And jumping on that point, I guess the easiest way to say it is, we don't judge. We're in this job. We do this thing for a living. We know these things happen. There's always a case that's worse than the one that you think you have, and we would rather hear about it. We would rather work with you to resolve it or fix it, or to tell you, hey, yeah, that's not great, but here's how we're going to do it for you. Or say, hey, we can make a call. We can have someone make a call, and try and resolve it for you. It gets worse over time. Not just financially. I mean, statistically speaking, the longer something dwells on, the more expensive it gets for you, for carrier, for resolving it. But also, it wears on you, just mentally, emotionally, just having this thing over your head. In a sense, that is also why we're here, is to provide risk management. And that's for ISBA mutual insurance. It's at no expense to you. It doesn't matter if you're a named partner or if you're a law clerk, or, I don't mean to do it this way, but just hierarchy wise. That's why we're here. And some of the things that we talk about in terms of, ways that the associate, the law clerk can assist. One of the things we talked about is documenting everything. Document, err on the side of documenting. If you have a phone call with opposing counsel or your client or the judge's clerk, document those things. If you're gonna think about it later, put it in. We have the access. We all have the access now to our phones to put in, just notes saying, hey, update this information, write this letter, send out this email. The more you document, the more we can defend you, I guess is the way to say it. If it's he said versus he said, or she said versus she said, that becomes just a little more problematic. It's something that, Angel's got a question.
Well, I was just gonna yes and. I have found, because I actually had to litigate some of these, fortunately not personally, but I helped. If you have a practice of always documenting and there isn't something in your file, the fact that you always document can prove that it didn't happen. So it's not only the documentation of the thing, but it helps you prove the lack of this other thing that you don't even know you need to defend didn't happen. So having the document is helpful, like for layers of reasons.
Right.
Great point.
Great
Thank
point.
you. And we have, Andrew and I and the other members of the mutual, we work kind of, one of the things that we do is update templates. So we have templates, we have engagement letters, non-engagement letters, disengagement letters. Who knew there was a non-engagement letter?
Right.
Did you know there was a non-engagement letter? I didn't know there was a non-engagement letter. And we have, like I said, and this is all based on 30 plus years of defending insureds and seeing what they run into. We have a lot of folks, we get a lot of pushback when we say, you really should have an engagement letter. And they say, I've been doing this for 25 years. I have 15 claims a year from this, or assignments a year from this one client. You're expecting me to write an engagement letter every single time? And we say, we'd really like you to. Because it defines the scope of your responsibility and it helps us along the way.
And it is the first line of defense too.
Yeah.
If there's a dispute, that's going to be one of the first documents that we go to. Say, what were the agreed upon terms?
Yeah.
What was the scope of representation? What were the fee and that kind of thing? Because if it's ambiguous, then that creates issues. Because we have seen situations where there might have been like a kind of a little bit of a loose contract or kind of a verbal contract where the lawyer left that meeting thinking there wasn't a client retained. The client, so to speak, left that meeting, thinks they just retained counsel. So they might anticipate that that person is going to perform the legal services. Then the lawyer gets sued, then it goes to court. And the court has a tendency to side on the side of the client that, okay, we talked about some detailed things. In our opinion, there was a verbal agreement that counsel was retained. So the more you document, anytime there's guesswork with the client and attorney, it has more of a tendency to go sideways than not.
Yeah.
So the importance of that document is very, very critical.
And we even when I retain attorneys to represent our insureds, we have some of our attorneys send us disengagement letters. Like we tried this case to verdict, it's over, you've paid your final bill, here's your letter, don't talk to me again about this file. I'll retain it for 7 years or whatever. Or we just settled the case and it's the same thing. So I would say things like, one of the benefits I think that the newer lawyers have is you've been trained in an era of technology, and some of it's super scary. We can get into wire fraud, but I don't think we have 4 hours to talk about it. But what we find is a lot of people get stuck in their ways of doing things. It's worked for me for 25 years. It should work for me for another 25. One of those things is documenting. One of those things is writing a letter versus an email or a text message or what have you. And, in terms of the things you can bring to the table is educating those lawyers who've been doing it for a long time with whom you work, and educating them on what's out there, what's available, not only in terms of maybe risk management software, case management software, diarying, but also like what not to do. Don't use, try not to use a text message. I mean, I tell people all the time, don't use your personal phone for texting business. I don't know who listens. If usually it works with people who follow football because you hear Tom Brady and text message, and everyone knows not to do that anymore. So that's one of those things. I do want to touch on one thing once we get, now we've talked about documenting. I know Andrew and our whole kind of team, we do data, we take data, we take information that we get on claims, and we categorize things in order to try and provide the best risk management to the most people. And I know, and we run into sort of, I don't want to say the same fact pattern, but certainly the same areas of practice that many of you dwell in, claims tend to surface, or at least potential claims, or they tend to be risky. And I think Andrew's kind of has a good list for you on what those are, and I can probably provide some claim examples. Everyone loves a good claim example, so I'll turn it over to you for that.
Yeah, so a quick little trivia, because year over year, there's the 5 same areas of practice every year that produce the most claims. So just kind of a little trivia here. Can anyone guess the number one year over year, and it's by far the most common area of practice that produces the most claims?
Family law.
Close. That's actually in the top 5. Obviously, with family law, it gets contentious. A lot of times with family law, there's money involved in that kind of thing. But since it's an emotional area of practice, the one part that's that's really applicable to family law too is ARDC complaints as far as coverage goes. Because if something goes sideways, they want to blame it on their attorney. My attorney did a crummy job. So with legal professional liability insurance for covering legal services and potentially any kind of disciplinary complaints and that kind of thing. But the number one is personal injury. Anything that's involving money, and people get a little contentious. Kind of one thing that happens quite a bit, especially with personal injury lawyers, is the injured party tends to do their own research, their own lawyering, and they think, oh, my slip and fall at a 7-Eleven, that's worth hundreds of thousands of dollars. So that's where we kind of see a different, expectation with clients. Who are like, this is valued so high. So it's one kind of thing, and importantly is, if you're dealing with an injury matter, kind of direct them in what their client expectation is, because if it's completely unreasonable and there's no prayer of getting hundreds of thousands of dollars judgment on that, that's one area where we see a decent amount of claims.
Yeah, the one of the questions that we ask is, how did you communicate that expectation with your client? Did you do it via email, phone call, Zoom call, written letter? And what we often get is, well, the person walked in the door, I said I'd file a lawsuit for them, and we didn't really talk about a result or what to expect. And that's just one of the things to do to avoid legal malpractice claims is to have that clear line of communication. And Andrew's point is a great one. We have cases now where, the person thought, I should have gotten more money. We have cases where I should have gotten more money and you pressured me into taking less.
Right.
So when you're giving your client bad news, which you should also do, if, don't just sugarcoat it. If the case is going poorly, manage their expectations, notify them immediately. And if they fire you, they fire you, but at least you have clearly communicated your impressions of the case and where it's going. ARDC claims are, I don't know the percentage, but every ARDC claim pretty much has a complaint of lack of communication. I walked in, I signed a retainer, I provided a retainer, they filed a lawsuit behalf, I didn't hear from them for 8 months.
Mhm.
I went to their office, no one was there. I picked up the phone, no one returned my phone call.
And even from a communication standpoint too, just not ignoring your client is critical as well, because if there's no activity and nothing to report on, even if you let that person, we're at a little bit of a standstill right now, but I'll keep you updated on, any progression. That's great, because when a client feels neglected, that's when the emotions come into play, and they're getting upset even though there's nothing, substantial to report on.
Yeah, the one of the things to Andrew's point about the personal injury type of cases, the problems that we run into there and why they're so frequent is, and I have been told the reason why plaintiffs' attorneys do this. They wait to file their lawsuit on the last day. 3 day, whether it's a 2-year or 1-year statute. And if you diary incorrectly, if your sole resource of information was your client, you didn't look up the medical records, you didn't verify the date of the accident, there is no going back. So we run into statute problems a lot, and it won't surprise you to know that often it's when a municipality is involved, the person driving that truck or was, delivering something on behalf of the government or something, and it's all of a sudden comes a 1-year statute of limitation that you thought was 2. And again, there's no going back from that, and we see this all the time. So one of the things I'll say is document your date of injury, document your statute of limitations, verify it every single time. Don't assume that you know what the statute of limitations is. Dive deep, find all of the owners, find the partners, find who owned the building, who owned the car, who owned the truck. All of those things can weigh in, and don't wait till the last minute. I know why people do it. I know they're waiting on responses to demands from insurance companies. Just don't do it. It's just it happens so much, and it's a dream for a defense attorney, which is what I did. Just look at the complaint and say, like, this is going to be over in about a month. And then you have to report to your client that you did it. You gotta get a letter and says, I screwed up, and here's my insurance carrier's contact information. And that's what we do. So those are things that we deal with. One of the things I think in terms of communication, again, I want to get back to is when you have those hard conversations with your client and you say, we got an offer. It's much less than what you, my client, Mr. Client, Ms. Client think it's worth, but you have to strongly consider taking it because they have this defense. This piece of medical evidence didn't actually turn out the way we're going to have it. Whatever the reason is, if they disagree with you, that's fine. Carry on. I want to try the case. I want my day in court. Great. Document all of that. I presented the offer on this day, explained it in this way. They rejected it on this day, despite all of those, all my warnings to the contrary. Those are things you can do at a daily basis to help avoid that miscommunication that inevitably leads to ARDC or a legal malpractice complaint. At this point, I'm just going to we're going to take a quick break to see, does anyone have any questions, comments, concerns? It doesn't have to be anything we just talked about. If anything's just bugging you, we can certainly take a second and answer any questions you might have. Take that as a no.
Yep, nothing at this point.
All right. What else can we talk about?
One other thing too, it's kind of when you're starting at a new law firm, whether associate clerk, that kind of thing, is one thing that we kind of encourage is have to thinking of being a business owner yourself. how would you kind of go through progression of client selection and, identifying conflict of interest, use of engagement letters, and that kind of thing. So we have some resources that we'll share with everyone, kind of our loss prevention manual. It's really detailed, a lot of really good information on kind of how you kind of structure, almost like kind of building your own business and that kind of thing. So there's a lot of resources just that we encourage you to use either through us, through the ISBA. As a newly barred attorney, you automatically get a free membership. I saw that both the attorneys on the call are ISBA members. So they have a huge library of kind of how to educate yourself. I'm not sure if anyone while they're in law school got their free ISBA membership with that, because as a law student, you have access to an ISBA membership, all their benefits and that kind of thing. You can join section councils to kind of learn about the area of law that you're involved in. I saw that most of the firms that are part of this program are general practice. So it gives you a really good, broad category to become kind of well-rounded and educated in multiple different fields and that kind of thing. So there's so much information on, different outlets and that kind of thing. So we just kind of encourage kind of educating yourself. Obviously, you're going to get mentored through the firms that you're with, but self-education is really important as well.
Yeah, to that point, I know, mandatory CLE is a drag. But it is actually an opportunity, if you take it seriously, to really educate yourself on things. I mean, there are cases that come down, that you may not think impact you. I mean, I don't know how many. Again, I'm gonna ask people to raise their hand, but they're not gonna see them. But if you haven't heard of the Midwest Sanitary case, I strongly recommend you go look at it, because it significantly changes the exposure to lawyers in the state of Illinois. It's an Illinois Supreme Court case that came down in September. But I can guarantee you probably any CLE that's been produced in the last month and going forward that deals with litigation or punitive damages or jury verdicts or jury selection should address that case. We have had to take a look at how we are tracking jury verdicts throughout the state as a result of that case. It's just a requirement now that we look at that. I've told our team it's a requirement that we look at that more than we did, because those are, anytime a punitive damage is entered against a defendant, that's a potential malpractice claim that might be recoverable against one of our insureds, as the law currently states. So my point being, take those CLEs, improve yourself, improve your knowledge, put the time in to educate yourself. Use the resources that we have here at the Mutual, the ones that are at your firms, the ones that are through the ISBA. They're there for a reason. And find out if a carrier is not the Mutual, what is their risk management, phone number, contact information. And there are lots of resources out there to help you. But the number one is your mentor. So make sure you're in communication with that person. If you think some of the things that we have talked about today, you're not able to talk to people about, I would say, I hope you're wrong. They've engaged in this process, this rural practice initiative, with the idea of bringing in and mentoring, attorneys such as yourselves. So they knew what they got into. So you should definitely use that use their experience. And again, you have a lot to add to the table in terms of what you have learned over the last 3 years, 4 years, 5 years, what have you, in terms of the technology, the things that are out there to help you practice, and the like. We can talk a little bit about legal malpractice insurance if that's what you want. You probably don't want to, but I'm going to anyway.
Before we do that,
Yes.
can I chime in for a moment?
Please.
Yes.
Please.
I will just say, one of the things that my first boss said to me when I started straight out of law school was, you should really treat expect that some point during your career, you're going to have to respond to an ARDC complaint. He said it's kind of like a car accident. Ideally, the only car accident you're in your whole life is a little fender bender, easily resolved, move right along. Maybe it'll be major, but hopefully not. But just expect that it's going to happen and do what you can as you're practicing to act accordingly. Expect that that's going to be part of your process. That was helpful for many things, including the fact that it sort of made me feel better in case that did happen, that I would be able to go into his office and say, it happened. But also I thought that it was sort of a good outlook where you should not feel as though you were the most terrible person in the whole world, and don't beat yourself up. It is a problem that most attorneys face at some point in their career. I'm not saying go around and purposely commit malpractice or purposely trigger an ARDC complaint, but just don't hold yourself to an unreasonable standard of never upsetting anybody, because that's probably not going to be possible. So I found it helpful. I will say thus far, no ARDC complaints. So knock on wood, my problem is down, much further down the road. But I still fully believe that, as he said, I'm going to have to spend a couple of Saturdays in my office going back through a file and providing all the paperwork to respond to whatever it is that there is. But
I think that's a great point. And one of the things that we talk about is twofold. 2 points I want to bring up. One is sort of what are those areas of practice that Angel sort of was talking about, that and Andrew was talking about, that sort of fortunately make up the most of our ARDC complaints, and that's the BI, PI stuff.
Mm-hmm. Real estate, family, state trust, collections, and bankruptcy. So kind of the underlying theme is a lot of those have to do with money, and some of these have to do with emotions too.
Right.
And Angel, to kind of your point too, with an ARDC gripe or even a malpractice situation, a lot of them stem from just an emotional kind of situation. So not necessarily wrongdoing. They just got, they're upset about something, and to kind of help kind of alleviate the concern of like ARDC gripes, it happens all the time. I mean, 99% go nowhere. The ARDC will respond to the ARDC, will review it and say, okay, there's no further investigation. There's no wrongdoing. Understand this person was upset about something, but as a lawyer, you did nothing as far as the practice of law or anything like that. So I know, especially in kind of the newer years of being a lawyer, I recently talked to someone and they were barred for maybe 2 months and got an ARDC complaint. It was, the sky is falling. What have I done? I'm a bad attorney. I was like, no, you're not. It went nowhere. It just happened that someone was upset. You did everything perfectly. Just they wanted events and they vented it through the ARDC. So, yes.
I would submit that the one thing they didn't do perfectly probably is communicating with the client. Because I will tell you that the most common complaint that I get from clients who come to me from other attorneys is that they weren't communicating and that they are wildly dissatisfied with the lack of communication.
Right.
And so to the extent that you can maintain communication and return phone calls and emails, even if it's just to say, I'm so sorry I haven't gotten to that project yet, I'll get to it by, and then a reasonable deadline, whatever you can actually do, because they'll expect you to do it, will go a long way. Yeah.
Absolutely.
Yeah, those are excellent points. And I will say this for the uninitiated, twofold. One, the ARDC investigates, or at least opens a file for every complaint. So whether it says, I had one where it was a landlord tenant, but the lawyer was the landlord. They weren't the lawyer. They just were a landlord that happened to be a lawyer. And the tenant filed an ARDC complaint saying this person wrongfully evicted me or something, to the point where it had nothing to do with their professional service as a lawyer. But the ARDC opened it up, made a couple inquiries, closed it immediately. So the point being, every complaint is going to get opened and reviewed. To Andrew's point, most of them go by the wayside. What I will say is, and again, I'm doing a rhetorical question to people who I cannot see, does your insurance policy provide ARDC coverage? The answer, if you're a mutual insured, is it provides a defense up to $25,000. So if you're a mutual insured, and most carriers policies that I've seen provide some amount of defense in terms of dollars, to hire an attorney for you to gather all those documents Angel was talking about, and prepare a response to the ARDC or whatever disciplinary proceeding commission is inquiring about you. We have found, and I'll take a little plug for our policy, or for our panel, I should say, we have found that when an attorney, a third-party attorney who's not related to your firm, prepares the response and issues the response to the RDC, we get much better results than when someone answers on their own and writes 15 pages about how much that attorney did for this particular claimant, how dare he send the ARDC a complaint. They don't want it. They don't want to look at it. What you want to do is you want to get it clean, just the facts, no fluff, no exaggeration of what happened. And most of the time, I would say 9 times out of 10 or more, closed, no further action, be on your way. Check your policy, see if you've got that coverage. If you do, a lot of people don't know they have it. If you go to your partners and ask them, do we have ARDC coverage? They're probably going to say no. Check the policy, they probably do for the defense. Which also goes then to reporting. So as I indicated at the beginning, lawyers' professional liability insurance is what's on a claims made and reported basis. What does that mean? It means as soon as you have a claim, as soon as you know of a problem, as soon as a demand is made, as soon as you get served with a lawsuit, as soon as you get a whiff of anything, call your insurance carrier. That's what triggers the coverage. So timing is of the essence. Depending on the carrier and depending on what the policy says, you can, there might be coverage and there may not. You may be covered by one carrier and not another. And one of the things that we then, we need information when we get a complaint, a notice of a claim. What was the date of the accident, or who was involved? What was the date that they're claiming you did something wrong? What are the damages? How long was the representation? What was the nature of the representation? Or was it something where we get complaints all the time of, I don't even know who this person is. I got sued and they're claiming I was a lawyer at this law firm, and now they need a defense, which we have to, under the right circumstances we provide. People get sued for all kinds of things, as you can imagine. The point being, you've got to report these things as they come up. If you're reporting it to your partners and they're not reporting it to us, you are insured. You have every right to report a claim and ask for help as they do. I strongly recommend you keep them in the loop because they will find out, but that's not something that you can just report it to your partner and say, all right, I'm done. I wash my hands of it. Which goes to, again, sort of the question of who's an insured. One of the things that we get complaints about is about staff, non-attorney staff members. So executive assistants, secretaries, receptionists, law clerks. And once, those of you who are attorneys on the call and those of you who will eventually pass the bar and become attorneys, you may have the benefit and the burden of having a staff. And it is, it's your obligation to make sure that those individuals are doing their jobs to support you. But ultimately, the buck stops with you. And I'm sure Angel will tell you that the very bright attorney who told her, consider everything as a potential ARDC complaint, probably also told her, never blame your staff. Staff, that is just the worst.
Externally, definitely never blame your staff. Internally, obviously, there's teachable moments and you those kinds of things. But yes, externally, everything is my fault. I apologize for everything. If I have to
Yeah.
apologize for something that someone else did, they will hear about it between us. But externally, it's on.
Great point. Oh, something just popped up on our screen. I was trying to read. So yeah, the worst thing we can externally, yes, is to blame your staff. Internally, yeah, those are teachable moments. That's a great point. And it's because of technology, because of honestly COVID, because people are working remotely so much more. We have found, people are relying on their staff to do those things more often less I won't say unsupervised, but under less supervision. We had a claim where a paralegal coming back from COVID opens up her emails and just starts, she got back, told everyone I'm back, starts working from the bottom and going through things and sees a particular transaction that needed to be done. And her, we had a compromised email in the middle of it. She didn't pick up the phone. She didn't call, to verify the wire instructions. She just was so busy trying to catch up. She just thought, this one's an easy one. This one's an easy one. I'm going to knock this out. $325,000 later, was the teachable moment. So those things happen. Ultimately, yeah, we get the claim in and we ask who was involved, and yeah, paralegal so and so. But really, it was attorney responsibility. So finding those teachable moments, maintaining some semblance of control over that work, will help you in the long run. But know that their work is also covered. So if that paralegal's work was a covered claim by the firm and by the mutual. So that's something else I just wanted to touch on about staff. It's become such an important thing, risky from a risk management point of view, that we're working on preparing some risk management for paralegals and for those staff members who are more involved, I guess I would say, in the day-to-day business of the firm, because that's where we see claims come from, and if we can help, that's why we're here. Yeah, so I think, we're about, almost at the top of the hour. I think I'll just kind of open it up to any questions about insurance, about law, about claims, have you heard any good stories, claim stories you want to hear about, or questions that maybe you heard at the bar that you want to wonder if that's possible? We're here to provide information or to answer questions.
I would just say
And-
to the young
go ahead.
associates, I would strongly suggest going to your supervisor before you call the insurance company, because that would be the much better way for them to find out than from the insurance company.
Good call.
As someone who has had to go to one supervisor and say, I've made a mistake, we need to report this. Fortunately, nothing has materialized into anything that became a thing that needed paid out or a lawsuit or anything that dramatic. But in terms of reporting the ISBA mutual, yeah, I've definitely had to call them. So don't be ashamed. It happens.
No.
Right.
As soon, they're on your side. Imagine it the way you would want your clients coming to you. When they come to you after the problem has already blown up into this ridiculously huge situation, and you just think, if you just called me 3 months ago, this could have been so much better. You're on the other side of the line. So just remember, they're on your side, call them.
Correct.
That's right. That's a great point.
But what I'll do, I'll send everyone our loss prevention manual that I mentioned earlier. So if anyone wants to ping me or Garrett will be on the email as well.
Yes, please.
Anything at all that you want to talk about privately or anything, question at all. Again, a completely open forum. So anything that you want us to address, we'll try to provide the best insight that we can. If we don't have the answer, we'll get an answer for you. So always feel free to contact us for, open-ended inquiries.
And that's whether you're an insured or not.
Correct. Yeah.
We're here to assist the lawyers of the state of Illinois. So, thank you. Yeah, thank you all for participating in the Rural Practice Initiative. We think it's we enjoy doing these things
For sure.
So hopefully we'll meet you sometime in person And we're always here to answer your questions. And thanks for setting this up, Krista. We really appreciate it.
You're so welcome. Thank you guys, and thank you to all our associate fellows for attending today. We will have a recorded version of this in case you want to go back and review anything that was discussed on ISBA Central here, hopefully in the next week or so. But thank you all again. Have a great afternoon and a great holiday
Thanks.
season.
Take care, all.